Hi, I am Sakina Shrestha and today I will be presenting a comparative analysis of the Australian and United Kingdom legal systems, and I will also advise the board on the most appropriate business structure for engaging in cross-border trade and analysis director duties and corporate accountability under Australian law. This presentation integrates legal theory and practical application to a business scenario involving international trade between Australia and the United Kingdom. This presentation evaluates key similarities and differences between the Australian and UK legal systems, particularly in relation to the court hierarchy, constitutional structure, and sources of law. It then applies Australian contract law and consumer protection law to a proposed international supply agreements. This presentation further examines the proprietary limited company structure under the Corporation Act 2001 and evaluates directors' statutory duties. Finally, I provide a recommendation aimed at minimizing legal risks while promoting sustainable corporate governance. I will begin with a business scenario to set the context. Then I will briefly explain how legal system developed. Next, I will outline the key Australian law relevant to the business. After that, I will discuss the proprietary limited company structure. And then I will also cover director duties under corporation law. And finally, I will finish with a conclusion and my recommendation. In this scenario, an Australian manufacturing company is preparing to enter a supply agreement with a UK distributor. Because this is a cross-border agreement, both parties must understand the legal environment in each country before signing the contract. International agreements come with several legal risks. The first contract is enforceability, ensuring the contract is valid, clearly written, and enforceable under both Australia and UK law. The second is liability exposure, identifying who is responsible if products are delayed, damaged, or fail to meet standard. And the third risk is regularity compliance. Both countries have different rules and rules around the product safety, consumer protection, import or export requirements, and quality standard. There is also an issue of jurisdiction, deciding which country courts will handle disputes. And another important factor is directors' duties. Directors in both countries must act in good faith, avoid conflict of interest, and ensure the company complies with the law. If they fail to meet these duties, they can face penalties, fine, or personal liability. Understanding these risks helps the business create a legal sound proposal and reduce the chance of dispute when expanding into the UK market. Both Australia and the United Kingdom operate under a common law system. Australia inherited its legal framework from the UK. However, after federation in 1901, Australia adopted a written constitution. This constitution limits parliamentary power and allows the High Court to invalidate legislation inconsistent with constitutional principles. In contrast, the United Kingdom has an uncodified constitution and follows the doctrine of parliament sovereignty. This means Parliament can make or repeal any law. Both jurisdictions apply the doctrine of precedent, also known as stare decisis, where lower courts must follow decision of higher courts. A foundational case influencing both systems is Donaghy versus Stevin, which established modern negligence principles. The key analytical differences is that Australian constitutional supremacy creates stronger judicial oversight compared to the UK. And then in Australia, the highest court is the High Court of Australia. Below it are the Federal Court, State Supreme Court, and the Lower Court. Whereas in the United Kingdom, the highest court is the UK Supreme Court, followed by the Court of Appeal and the High Court. Australia operates under a federal structure, meaning powers are divided between Commonwealth and state governments. The UK operate as a unitary system with parliamentary sovereignty. From a business perspective, Australia's constitutional review mechanism enhance regularity, certainty, and investor protection. Turning to the Australian law relevant to this scenario, first contract law require five essential elements, and the elements are offer, acceptance, consideration, intention, and intention and capacity. These principles were famously illustrated by Carlyle versus Carbolic Smoke Ball Corporation. For international contract, clear drafting is essential to prevent dispute and possible frustration of contract. Secondly, the Competition of Consumer Act 2010 contained the Australian Consumer Law. This legislation prohibits misleading or deceptive conducts and ensure mandatory consumer guarantees. Failure to comply may result in significant financial penalties and reputational damage. Therefore, compliance is not optional, it is the central to risk management. The recommendation structure is a proprietary limited company or private limited. Under the Corporation Act 2001, a company is recognized as a separate legal entity. The principle was established in Salomon versus Salomon and Co. Limited. The key advantage of private limited companies included limited liability for shareholders, perpetual successions, and centralized management. Limited liability protects personal assets and encourages entrepreneurship. However, it must be balanced with strong regularity oversight. And directors' duties are central to corporate accountability. Under the Corporation Act, director must include exercise care and diligence under the Section 180, act in good faith under the Section 181, and avoid the misuse of position under Section 182, prevent insolvent trading under the Section 588G. A relevant case is Australian Security and Investment Commission versus Classimatis, where directors were held personally liable for breaching their duties. This demonstration that limited liability does not eliminate personal responsibility. From an ethical perspective, director accountability promotes transparency, protects stakeholders, and strengthens investor confidence. Corporate accountability mechanism includes oversight by Australian Security and Investment Commission, civil penalties, criminal sanction, and shareholder remedies. These mechanisms ensure that limited liability does not result in irresponsible conduct. Ethically, director must balance profit making with compliance and social responsibility. Strong governance enhances long-term business sustainability and trust. In conclusion, Australia and the United Kingdom share a common law heritage but differ significantly in constitutional structure. Australia's written constitution provides stronger judicial oversight. Operating as a proprietary limited company or private limited company offer liability protection, structure stability, and commercial flexibility. However, director must strictly comply with the statutory duties. My recommendation is that both operate as a private limited company and implement robust compliance and governance system before entering international contract. This approach minimizes the legal exposure while supporting sustainable growth. Thank you.